Shalom, my name is Michael Decker, and I am a lawyer within the law offices of Cohen Decker Pex and Brosh. Today I wanted to discuss a certain topic with regards to houses of prayer and worship in Israel and their entitlement to a full Arnona exemption. And I wanted specifically and particularly to discuss non-classic houses of prayer and worship, like churches with steeples, mosques, and synagogues that are clearly seen as such. And particularly churches of foreign workers. There are many Filipino churches in the country, churches of Eritreans, Sudanese here, Nigerians, also churches of Russians, of expat American workers, or from other Western countries that are here, and their entitlement to a full Arnona exemption. The relevant regulations are the governmental and municipal tax ordinance. And the governmental and municipal tax ordinance basically defines in section 5C J 1 that and 1A that a house of prayer and worship, a church, and a synagogue, or another type of house of prayer and worship are entitled to a full Arnona exemption. However, this relevant ordinance also in section 4 discusses an exemption for a house of prayer, and the exemption for a house of prayer in section 4 doesn't give a full exemption but a 67% exemption. And many times, and this is a particular issue I wanted to discuss in this video, many times when applications are applied for within the municipalities, the municipality says that the relevant exemption needs to be according to section 4, and section 4 refers to section 14 of the ordinance, which says that the superintendent over the district needs to decide whether this specific house of prayer and the possessor of the house of prayer is an official recognized religious community in Israel. And then the municipality basically says, until we don't get the superintendent over the district to confirm to us and give us a decision that this house of prayer is an official recognized religious community, we cannot recognize you as a house of prayer, and we cannot give you any exemption. And then these houses of prayers are billed at huge amounts of municipal taxes as if they were for-profit businesses. This question specifically arose in several cases that I took care of. In one case, it was a case in Ashdod called Amutat Derech Ve'emet against Ashdod municipality, where the municipality said that they don't want to give this Russian church full exemption of Arnona because this specific Russian church did not provide an approval from the superintendent over the district that they're a religious community. I submitted an appeal against this decision before the special Arnona committee, which is in the municipality of Ashdod, and I won this appeal, and the Arnona committee decided that the manager of Arnona in the municipality should himself decide on this question due to section 5C J1 of the ordinance, and that there is no need to ask for the recognition of the superintendent over the district according to section 14 because the request is submitted according to section 5 in the ordinance and not according to section 4. The municipality didn't like this decision, and they appealed the decision before the district court. And even in the district court where I represented the client, the judge sided in the favor of our client of this specific Russian church called Amutat Derech Ve'emet, and the judge decided that there is no reason for this church to obtain any recognition from the superintendent over the district, and that the manager of Arnona, based on his view, should decide basically whether this is a house of prayer and worship or not. So this Russian church received a full Arnona discount, and a bill of a couple million shekels was basically erased for this specific church. If you have any questions or clarifications regarding this video and this subject, you can feel free to write to us and contact us. Thank you very much for your time.